Dear students, in this class today we are going to discuss about one of the most important intellectual property rights protection, that is copyright and industrial design and integrated circuits. So, three topics are included in this particular class, and we will see basically what is the TRIPS obligations with regard to copyright and what are the other obligations which is came through the TRIPS agreement. So, in the last class also, previous classes also, we have explained that the other international agreements came through a backdoor entry to the TRIPS agreement. One such agreement is the Berne Convention, and we will see some of the provisions of this and the terms of protection, then design protection, the basic requirements and the term of protection under the TRIPS agreement, and the small provisions are with regard to the integrated circuits, and we will see these provisions elaborately. So, first we start with the copyright. So, everybody heard about copyright, but exactly what are the rights and obligations, and this is the one intellectual property law right violations can send you to jail. So, what are the punishments? Whether it is only the civil or the criminal punishments or penalties as well. So, what is copyright? So, copyright is considered, the WIPO gives a definition which says that it is a right, it is a legal term used to describe the rights that creators have over their literary and artistic works. So, copyright is more lean towards literary and artistic works. So, what is this literary work? Literary work includes books, music, paintings, sculptures, films, computer programs, databases, advertisement, maps, technical drawings, and I would say that simply whatever you write, you have a copyright. Whatever you have written with regard to music and other things, there are many people, those who are involved in a song, for example, a film song. So, there is distinct rights are with the musician, distinct rights are with the singer of the song, distinct rights are with the owner of that particular song who owns the copyright. So, author and owner may not be the same person, it can be two different people as well. So, and all these are included under the copyright. So, this is a 2023 case, and there is a storytelling platform in YouTube and other places, Humans of Bombay, and these Humans of Bombay, the platform has sued another storytelling platform which is known as People of India, and Humans of Bombay filed a copyright infringement suit. Copyright infringement suit. So, because when you look into this nowadays, it's everything is in online and the digital world. So, rather than so we talk about books and story books, academic books and other books, now everything is in the digital world. So, when it comes to the digital world, the infringement, copyright infringement become more important. So, this is basically these platforms basically tell the stories of common people. So, both these companies, that People of India and Humans of Bombay, have the similar interest. And for example, these one company have 2.7 million followers. So, it is not a small number of followers for this particular storytelling platform. So, here the court initial observations are very important. The court observed that there is substantial imitation of HOB storytelling platform by People of India platform, POI platform. So, this is a clear cut violation of copyright. So, even the court observed that even the photographs, images are an identical or imitative. So, these are the very initial the observations of the court. There is a prima facie case of violation of copyright. So, violation of copyright is a civil offence as well as a criminal offence. So, you have to pay millions of rupees as compensation, as well as you may go to jail as well. So, another the news item which you can see that. So, once upon a time in 2015, so the Delhi High Court has ordered the arrest of the Delhi University's Vice Chancellor and another student on violation of copyright. So, we call it as plagiarism, but plagiarism is nothing but copyright violation. So, you may end up in jail. So, in this particular background, we can see that what is this copyright. So, what are the ingredients of the copyright? What are the consequences of its violation? Literary works, novels, poem, plays, books, newspaper articles, and now the entire digital world is protected by copyright, databases, computer programs, and computer programs India there is no patent protection. So, computer programs are protected under copyright. Films, musical compositions, artistic, any kind of artistic works. It can be painting, it can be drawing, it can be sculptures, it can be photographs, even architecture, advertisements, maps, technical drawings, and also we will say that databases includes even compilations have copyrights. So, if additions to the even the famous case of whether the Supreme Court judgments are copyrightable. So, Supreme Court said that the Supreme Court judgments per se is not copyrightable, but if you add some value addition to it, you put headings, analysis, then it can be copyrighted. So, this is my book on IP and competition law, and I am the owner of the copyright and as well as the author of the copyright. That means, the copyright is with me. So, I have written this book. So, I am the author of this book and the copyright also with me. So, I am the owner of this particular book. I have 6, 7 books, and in some of the cases I am not the owner. I have given the copyright to the publishers and I am only the author. So, there is a difference between owner of copyright and author of copyright. So, we can see some of the famous cases. So, as I already told you that the copyright violations may end up in millions of the compensations you are supposed to pay. Here one movie, that is the famous movie Partner. So, ultimately it was found that it was a scene to scene copy of the Hollywood movie Hitch. So, the Sony Pictures filed a copyright violation case, and then the producers of Partner have to pay $30 million. So, there is huge amount of the huge amount of compensation you have to pay in violation of copyrights. So, you may maybe inspired. So, usually the film industry says that we are inspired by that particular story. You can definitely inspire by the story, but you do not have any right to copy that story scene by scene. You cannot violate the copyright of other movies. So, there is a connection. So, as I told you, many other agreements entered into the TRIPS agreement, and one such agreement is the Berne Convention of 1886. So, Berne Convention, now obligations are incorporated into the TRIPS agreement. So, the TRIPS agreement says the copyright obligations are given in article 9 to 13 of section 1 and part 2 of the TRIPS agreement, and also the substantive provisions of the Berne Convention. So, it means that the Berne Convention, most of the countries are not ratified Berne Convention, but the Berne Convention got a backdoor entry to the TRIPS agreement and through these particular provisions. So, now the Berne Convention 1886 is a part of TRIPS agreement, and we will see what are those obligations. So, here you can see the Berne Convention is basically adopted for protecting the works and right of their authors, the protection of works and their authors. So, here the mainly, as I told you, the focus was on authors, musicians, poets, painters, etc. So, they have the control over their works and whether to sell, whether to license, and they have the control over their works in what terms and conditions they want to sell it. So, the Berne Convention was provided minimum protection. What are the minimum protections granted? And also special provision available to the developing countries that want to make use of them. And also we can see that these basic principles in the Berne Convention. So, the national treatment principle is now applicable. So, that means same level of protection to be given in all member countries. So, that means if India is providing a special treatment to any of the others, then you have to give the same treatment to the foreign others as well. And also the principle of automatic protection, you need not to register copyright. The moment you have written something and the copyright is with you, and the registration is required in order to prove. So, the strong protection is required in case of copyrights registration, but actually there is an automatic protection, there is no need to register copyright the moment you have written something and you have the copyright with you. And also the principle of independence of protection, that is, so the origin of the work, whether the protection is independent of the existence of protection in the country of origin of the work. So, now all the member countries, all the 164 WTO member countries has to implement the minimum protection which is prescribed under the TRIPS agreement and not the Berne Convention, but the Berne Convention provisions are ended through the TRIPS provisions, and originally actually the members has to now implement the Berne Convention through the TRIPS agreement. And some of the provisions which you can see, the Berne Convention amended in 1971. So, which says, which provides for registration of computer programs. So, as I said that the countries like India, the computer programs cannot be patented, but it can be copyrighted. And and also the idea expression dichotomy, which is call it, then the copyright. So, copyright can be extended only to expressions of ideas and not ideas per se. That means, an idea cannot be copyrighted, only the expression of ideas can be copyrighted. In certain cases, the compilations of data, the compilations of materials, whether it is machine readable or in the form, that means databases in the digital form, this provision is applicable. So, that means compilation of data also can be considered as an intellectual creation, and the article 10(2) gives protection to such compilations of databases as well. The term of protection of copyright is provided in the TRIPS agreement is life of a natural person plus another such term shall not less than 50 years from the end of the calendar year of the authorized publication. That means, a full lifetime of the author plus 50 years is provided in the TRIPS agreement. And then again you can see that countries like India provides 60 years. So, life of the author plus 60 years. So, it is a TRIPS plus obligation. The term protection is provided in India. And what are the rights under the copyright? So, the copyright holder gets right to translate the work, right to make adaptations to drama or music or whatever it is. So, adaptations, the right of adaptation is with the copyright owner, and right to perform in public, whether it is dramatic or dramatic musical works, etc., performing rights. Then right to recite literary works in public, right to communicate to the public, right to broadcast and right to make reproductions and right to use the work as a basis for an audiovisual work. Most importantly, the moral rights. So, usually we call it copyright is a bundle of rights. What is this bundle of right? So many rights are with the copyright. So, these bundle of rights are with the copyright owners. And what is the protection? So, you can see that, so for example, the TRIPS agreement considers computer programs as literary works, and also the Berne Convention also approved this. And also rental rights are another right with the copyright owner. And for example, in the case of softwares or in the case of sound recordings, so right to prohibit the commercial rental of their works to the public. So, you cannot publicly put a music which belongs to somebody else. So, India there are a lot of cases, can you put in public meetings these particular musics or the music albums. So, and also you can see that commercial rights, rental rights. So, all these are with the copyright owner. And also we can see the protection. We already said that it is the life plus 50 years which is provided under the TRIPS agreement, and the unauthorized productions for a period of 50 years, recordings and music, unauthorized reproduction for 50 years. So, the life of the people plus 50 years. And then you can see that this comes neighboring rights. So far we have talked about the copyright, and now we are going to talk about the neighboring rights of people, those who are associated. So, who is these people associated? That protection of performers, musicians, singers, producers of phonograms, that is sound recordings, broadcasting organizations. So, it means that a performance of phonograms without authorization is a copyright violation. Reproduction. So, it is without authorization is very clear that by any means. Now, the authorization broadcasting, everybody knows that it is through the satellites or live performances. So, phonograms and indirect reproduction of their phonograms are also the violation of which will come under the violation of copyright. So, if you take Indian provisions, yes, we have a copyright law from and it is now the provisions of Berne Convention is incorporated. Computer programs are protected, data compilations are also protected, and India provides a TRIPS plus protection to copyright and life of the author plus 60 years, whereas in 50 years is provided under the TRIPS agreement. So, in short, I would say that we have given few examples. Copyright protection is a very strong tool to protect the intellectual property of every authors on literary and artistic works, and which gives a bundle of rights. Copyright is a bundle of rights, and the remedies and enforcement is also very strict. Remedies and enforcement is also harsh when compared to the patent enforcement. Here there are civil remedies as well as the criminal remedies, and the person will go to jail. So, we saw some of the examples. So, violation, so we simply say that it is a plagiarism, it is not a plagiarism, and people have to be very careful, and the TRIPS agreement gives the minimum protection. The TRIPS agreement gives the minimum standard of protection of copyright. Now, we go to the industrial design. And what do you mean by industrial design? What are the designs? Whether every design can be registered. What are the prerequisites of registration of design? And what kind of designs can be registered? And what are the advantages of design registration? So, here mainly the industrial design, the focus is on their aesthetical shape or look or ornamental aspect. So, it can include a 3-dimensional features or 2-dimensional features, or it can be shape of article and patterns, lines, color, even packaging, and the shape also, textile designs. So, we can see that a design contains a different ways. So, here you can see the two examples of design registration. So, one is a prototype of a tricycle and another one is of a design of a dress. So, both are registrable, the complete design of a product, a tricycle and design of a dress material, both can be registered. So, here you saw that the difference between these two. So, it can be maybe an industrial product, it can be a textile product. So, this market is always looking into this kind of new designs. So, if you look in the design, you can see the overall appearance of the product. So, this can be shape, a configuration, pattern, ornamentation, and when it is specifically applied to a product. So, that means it should give a unique visual appearance. So, if something is new, aesthetic, giving a new visual appearance, then it can be registered as an industrial design. And the categories can be either it can be manufactured, even handmade, or is any product. So, we can see that how these we are not looking into how that particular product is working, but we are only looking into the design of that particular product. So, the product as such may be registered as a patent, but the design can be separately registered as an industrial design as well. That means, multiple intellectual property protection can be on the same product. And you can see very clearly said industrial design focus is on ornamental, aesthetic features of a product, or very simple appearance of a product. So, the design registration not focusing on the technical aspects or the functional aspects, it is only looking on the ornamental or the aesthetic features. So, it can be simple colors, it can be a 3-dimensional form, it can be a 2-dimensional form, and it can be patterns or lines, colors, or a combination of these, or a combination or composition gives a special appearance. So, for example, the shape gives a handicraft product a new look, new ornamentation, new aesthetic look, then that handicraft can be registered as an industrial design. And also you can see the TRIPS obligations is provided under Article 25. What is the standard of industrial design protection? So, it gives independently created industrial designs that are new or original. That is the condition provided in the TRIPS agreement. Very simple, new or original, independently created. But if you are independently created from an already existing one, then also it is registrable. That means, you may have not referred to the earlier creation. Independently created new design can be registered. And also you can see if it is significantly differ from non designs. If it is not significantly differs, then there is no registration, and it must be significant difference and also independently created, then only you get a design registration. And also the technical or functional considerations are not the concern of design registration. So, design registration is basically looking into the aesthetic aspect. So, you can see the various three dimensional designs. It can be a car design, it can be a chapel design, it can be a bottle design, even a small clip. The shape of the clip is not the functional aspect, but the shape of chapel, the shape of a small stool. So, you can see the shape, it can be registered. So, even though it may be highly different each other, but the aesthetic aspect, the visual appearance, if it is new, then it can be registered as a industrial design, registered as an industrial design. So, industrial design protection basically provides these shapes, patterns, packages, containers, furnishings, household goods, and I would say that even textile products. So, we have registered 3 textile designs from the state of Odisha in the Kolkata office, design office. So, the textile designs also can be registered, and jewelry, electronic devices, textiles, I already said that. So, these all the designs can be get benefit out of registrations, and also you can see that there can be unregistered industrial design. So, all these protection is not available. So, it depends upon the national law. The India also enacted a new law, new design law. So, whether this is protected under copyright law or design law, the domestic laws will decide. For example, this particular design put in a paper, whether this can be copyrightable or not, always it is copyrightable, and it will depend upon in accordance with the domestic law of the country. So, there can be copyright, there can be design as well, design registration as well, but a paper design cannot get a design registration. So, you get only a copyright, and also minimum 50 industrial the production, minimum 50 copies to be made for getting registration for industrial designs. So, here it is natural products, artificial products, and also so it says the design, and the design is not the article. Article is different from the design, and design is not a trademark, and trademark is different from design, and design is an integral part of that particular shape, appearance of a particular product, and nothing to do with the patent, the technical functions, or you can say that the trademark. So, design registration, as I told you that India also adopted the same the same qualifications, new, original, and the old design, there are substantial changes from the old designs. Novelty, now the novelty criteria is applicable to designs as well. So, the only exception is contrary to public order or morality, scandalous, obscene matter, which cannot be registered as a design. Otherwise, if you comply with the basic obligations, it can be registered. Then design infringement. So, you cannot violate the design of others without the permission or license or purchase in case of assigning. So, you cannot copy somebody else's design. So, even though the design is expired, even temporarily is not infringement. That means, once it is expired, it is in the public domain. So, there is no violation if you do not renew the registration of designs. So, in the infringement you can see that fraudulent imitation. So, you can see the first one, there is imitation, deception, imitation of the article, imitation of the registered design, amount to infringement. Then again, sale of that particular article belongs to the same class. So, fraudulent imitation. Publish and expose for sale any article in the class in which particular that design is registered, known as the design or any other as any other product. Again, fraudulent imitation. All these will considered as fraudulent imitation. Then you can see that damages, civil suit, and also you can see the fine up to 25,000 recoverable as contract debt for every contravention, and maximum of 50,000 in respect of any one design. So, the civil suit can be filed for compensation, damages in case of the violation of designs. So, I would say that the design registration is nothing to do with patents, nothing to do with copyright, nothing to do with trademarks. So, it is an independent category of intellectual property, right. So, basically focuses on the aesthetic aspect, the appearance of the design, and the TRIPS agreement put very minimum conditions. And next is the layout designs, topographies of integrated circuits, another category of intellectual property law protected under the TRIPS agreement. What is this layout designs? And layout designs are of different types. Now, no electronic goods without integrated circuits, no electronic goods without integrated circuits. So, these layout designs to be protected, otherwise the imitation will be there, fraudulent imitation will be there, and the people those who are inventing this, no incentive for them to make it. So, layout design rights or circuit layouts. So, these are basically topographies of integrated circuits, and every computer generated equipment use this. So, you can call it as a computer chip, you can call it as a semiconductor chip design, or it can be a layout design as well. So, it is a two-dimensional representation of the three-dimensional location of electronic components in an integrated circuit. So, it is a board and the various materials in that particular board which connects each other. So, it is the circuit layout. So, the circuit layout determines the functions, and these have a great value for the electronic equipments, whether it is a mobile or it is a laptop or it is any electronic good. So, an integrated circuit or that particular chip layout design is very important for electronic devices. So, all electronic goods are working with these layout designs as well as the computer chips. So, without which they cannot work. So, the protection which is given to the topographies in the TRIPS agreement and also the integrated circuits. So, it incorporates individual electronic components within a single integrated platform. So many electronic goods in a single integrated platform, and that is the integrated circuit, and definitely it perform an electronic function. So, topographies, the TRIPS agreement provided incorporating the Washington Treaty, the Washington Treaty on Intellectual Property in respect of integrated circuits. So, this agreement, international agreement, this Washington Treaty on Intellectual Property in respect of integrated circuits is also a backdoor entry through the TRIPS agreement. So, otherwise the Indian equipment in a layout design which leads to a function, a hardware and with a software, or the entire board is protected under patents in many countries. So, the topographies and layout designs are separately protected as a category of intellectual property law under the TRIPS agreement. So, article 35 very clearly says the members to provide protection to the layout designs, that is the layout designs of integrated circuits, layout designs, and in accordance with the so and so provisions. And article 16 of the treaty on intellectual property in respect of integrated circuits is a part of now TRIPS agreement. You have to provide protections which are provided in those agreement to all the providers of that particular agreement as well. And here we can see the protection is mainly against importing, selling, distributing of commercial purposes and protected layout design. Integrated circuit, the protected layout design is particularly incorporated. The article incorporating such an integrated circuit, so it is continues to contain an unlawfully reproduced layout design. So, the action can be against any kind of reproduction without permission. But another provision says that an identical design can be created independently by third party, that is not prohibited. So, that means identical creation of any layout design by independently if you create, it is not a violation of, it is not an infringement, it is not an infringement of the layout design, otherwise it is violation of an infringement design. So, this layout design is one of the least the protected intellectual property in many of the places, because most of the countries does not have much attention to the protection of layout designs, because they every country purchases these layout designs maybe from China and other places, they import it and they incorporates the electronic things and they make the board according to their functions and incorporate into a another hardware. It can be a machine, it can be a vehicle, it can be so and so forth. So, the protection is mainly against importing, selling, distributing and also is mainly reproducing layout design. And India also passed an act in 2000, that is the Semiconductor Integrated Circuit Layout Designs Act of 2000, which completely incorporates the provisions of the TRIPS agreement. And now semiconductor and layout designs are also protected under the under India as well under this particular legislation. And members can go to the layout designs office and register their layout designs, and the protection time is 10 years. So, 10 years which can be renewed. Most of the intellectual properties can be renewed from time to time other than patents, and patent is fixed for 20 years. So, otherwise it can be renewed from time to time. So, layout design protection is available in India as well. So, in conclusion, I will say that these three categories of intellectual property law, and one is copyright, one is the most important and very strict implementation is provided under the copyright, and it protects all kind of artistic, literary and artistic works. That gives complete monopoly comparatively with compared to all other intellectual property. Copyright have the longest protection which is given, that is the lifetime of the author plus 50 years prescribed under the TRIPS agreement, and countries like India gives 60 years. And there are civil remedies as well as there are criminal remedies, and we saw examples that people can send to jail for the violation of copyright. Secondly, industrial designs, and industrial designs are basically focusing on an independent category of intellectual property, looking on the appearance, the aesthetic aspects or the patterns, colors, combinations, and it is not looking into the function. It is looking into the aesthetic aspect or ornamental aspect of a particular product, which can be a handicraft also, which can be an industrial product as well. So, the industrial designs production is also available, and as I already said that it is available to the textile designs as well. And violation, theft of film stories, theft of dissertations, theft of designs, textile designs, you may end up in millions of paying millions of compensation. Then layout designs, the minimum provisions are provided under the TRIPS agreement. So, intellectual property, even though it is a monopoly right, and definitely the minimum rules, minimum term of protection is prescribed under the TRIPS agreement. So, this is mainly for the social welfare, societal welfare and societal good. The concept of societal good, it is to encourage the society for the innovations. And I would say that, so all these three categories of intellectual property law helps the creator, innovator to keep his innovative work for a limited period of time, and copyright is the longest term protection is provided. And the next we will see that in the next class the other categories of intellectual property law, that is the geographic indications and trademarks. Thank you.